Before the meeting commences, I'd like to acknowledge that we're meeting on the land of the Gadigal people who occupy the Sydney coast, being the traditional owners. On behalf of the Local Planning Panel, I acknowledge and pay my respect to the elders, past and present, and the Aboriginal people in attendance today. So good afternoon and welcome to the Local Planning Panel. I think I'll get some administrative things sorted first up. Could we please make sure that everyone is on mute until asked to speak? And also could I ask, so that it's clear who's speaking, that the staff and everyone have their cameras off until they're asked to speak, and then put your camera on and on mute, please. Otherwise it just gets confusing because it's too many faces who's speaking. Fantastic, thank you. So I'm the chair of the panel. My name is Sue Francis, and with me are the other panel members who I will ask to introduce themselves and confirm whether they have any conflicts of interest. So I myself don't have any conflicts of interest.
Stuart McDonald, expert, no conflicts.
Thank you very much indeed. So we have 3 speakers today on 3 items, so 1 per item. So we will go in order, and the items will be 312 Rainbow Street, Coogee is the first item, 34 Frenchman's Road, Randwick is the second item, and 35 Douglas Street, Clovelly, this is the third item. So what we will do is I'll call the item, call the speaker for that item. Each speaker has 3 minutes. We may or may not have some questions after that. And then we will move to the next item, etc., etc. And then the meeting will be closed when we finish all the items, and then we will deliberate, and decisions will be made available on the council's website within the following few days. The important thing is to talk to the issues of the matter, not any personal issues, no derogatory commentary, and only registered speakers are allowed to speak, and it's the 3 people that we have speaking today. Please also remember to speak up. Tell me if you can't hear me as well. Speak up, speak clearly, because we are being, it's really important. This is a public meeting and it is being recorded. If you go longer than 3 to 4 minutes, I will probably call you up and ask if there are any further questions you want or matters you wish to raise, but we will try and keep them to a minimum. We may, as I said, ask questions that may allow you to respond to something you still wish to make. So the first item on the agenda that get going is 312 Rainbow Street, Coogee, which is alterations and construction of a dwelling house. Apologies. And we have 1 speaker who's the applicant, that's Mr. Simon. So Simon, yes, I can see you. Okay, hi. Simon, the floor is yours. You've got 3 minutes.
Look, we spoke briefly this morning. I didn't have much to add. I guess I'm probably disappointed with the process, in that we took actually great efforts to try and create a design that was sympathetic to the location. It feels like a lot of the council's objection to the property is based on a different view of FSR calculation to the view that we have, that our town planner took. I don't know what guidance the council in terms of case law is using in relation to the FSR at the moment, but as I understand the more recent case law, you know, stairwells, storage areas, etc., are not to be counted in FSR. Well, at stairwells, there's only half the area is to be counted, as I understand the most recent case law. So, and it feels like a lot of the remaining objections were really ultimately therefore built around, oh, this house is of excessive bulk and scale, so, you know, everything else is a problem. So, you know, we don't have enough planting on the site, but then we have trees that are blocking our neighbours too much. You know, we've tried as far as possible to meet all of those objectives. as you'll see from the pictures of the house, every level has planter boxes on it to try and soften the visual appearance for our neighbours. The original design from the architect was presented with much more bulk to the east, and we pushed the top level back, both to soften the view to those, sorry, not to the east, to the north, both to soften the view of those to the north, but also to lessen the impacts on our neighbour to the west, number 310 Rainbow Street. As I said, there's extensive planter boxes. So all of those on Wolseley Road, who I should add, as you saw this morning, all have very large trees in their backyard, which will screen the bulk of this house. We'll also then be looking through to our planter boxes. And I should say the planter boxes were added not just to create a visual appeal for our neighbours, but also to force those inside our house to be not standing right on the edge of the balcony, but to be stepped, half a metre back from the balcony so that they're not looking down into our neighbours' yards. Because we have no desire to do that any more than I'm sure they want us to do it. And as you would have seen at the moment, the current balcony is literally on the boundary of the Wolseley Road neighbour. So obviously that will no longer be the case. In terms of the street frontage, I mean, our neighbour, again, to the west, their garage is built on the street. So the idea that there's no adjoining neighbours and therefore we should be compliant with a 6 metre setback from the street feels a bit inappropriate and excessive. We're 4.5 metres setback from the street, which is significantly more than our neighbour at 310, and was designed to try and get cars off the street, because as you would have all seen this morning, this street is difficult to navigate at the best of times, and I can assure you on the weekend there is no parking. So we're doing our best to make sure that us and our visitors are off the street so that we'll create more parking available to visitors to the area. Where it's in quite hot demand. So I guess, that I guess was the core of it. I mean, in terms of the height, we're compliant with the LEP, there was discussion about whether we should be complying with 2 stories, but, the area is full of 3-story houses that step down the hill. And ours is a house that steps down the hill. It has to, it's on a slope. So it presents as 3 stories to the back and 2 stories to the front. Again, we tried to, as I mentioned, set the top level back to try and soften the view from the north. I don't think there's much point in going much further. I guess the one last point I would make is, there were, I believe, some, 20 plus objections or whatever it was. The 2 things have happened as I understood it. One is apparently they were approached by someone who our town planner jokingly calls an ambulance chaser, who basically approaches neighbours and puts together a template objection letter for as many of them as want to pay him as possible. And apparently a number of those letters were exactly that. And then our immediate neighbour to the west put in an objection, had his mother in Warringah or somewhere put in an objection, and every other person that he knew put in an objection. Now, as I mentioned to you this morning, that neighbour to the west purchased their place after us. He specifically bailed me up when he was looking at the property before they purchased it and said, "Are you building?" And I said, "Yes, we are. We're going up and we're going to the back, to the north." And he negotiated with the agent and with the vendor on the basis that he knew we were building. So I'm disappointed because it's going to cost council a lot of money. I don't want to be going to the Land and Environment Court. I really don't. But it's going to cost us a lot of money and it's going to cost council a lot of money. And it feels like there was a failure to communicate here at a level that could have seen a better outcome for both sides. So I guess that's the key thing I wanted to leave you with.
Thank you for that. I think there are matters in here that may be able to be addressed, but which haven't, and leave us with situations, with technical situations particularly in relation to the issue of GFA. I might take, I might disagree with your expert planner on that in terms of what's been included in the GFA. It may only be a technicality, but it is a legal technicality that we cannot treat. The absence of a variation to that standard, even if everything else was perfect, we could not deal with the matter. So that is something that needs to be addressed by your expert planner. And that particularly, as far as I'm concerned, relates to the storage, which is meter above ground, and the laundry, which is not excluded.
I'd agree. Sorry, I'd agree with you on that. I just feel that our town planner and your town planner could have communicated to discuss which case law they were using and relying on in their calculation.
It's pretty fundamental. It's called the definition, which all of us use. You've got over 100 years experience in planning sitting around this table. So
I get that. I get that.
But can I just say that there are things that need to be addressed. I would encourage you to keep the dialogue open with council, because the opportunity is not gone in relation to being able to address some of these things. Some of it will mean you have to provide further information and clarification. It does mean you'll have to provide this information, but I urge you to do so. But in the absence of, in the various minimum of clause 4.6, there's not much we can do on this. I'll ask my fellow panel members whether they have any particular questions or queries.
No, nothing further. Thank you.
Okay, so I would urge you, as I think I did this morning, to look at the issues that have been raised with your plan. They're going to have to be addressed if you go to court, so you still have the opportunity to have a meeting with council to resolve it, and I strongly urge you to do so.
Yeah, well, I hope we get the opportunity to do so as well. I think it would be.
You have the opportunity. You have the opportunity. You just have to make contact. Your expert just needs to contact the assessing officer.
Okay, well, that might have been helpful prior to us receiving a letter saying that our application was to be rejected unless we withdrew it. So a dialogue, from my point of view, would have been helpful ahead of that.
Nonetheless, you've chosen to go to court, so
after we knew we were going to get a rejection, after you made it clear that we were going to be rejected.
Just be careful using the term we. We are not the council. We're an independent panel, so it's not our planner, and we are not the council.
Okay. Council made it clear.
So I encourage you to certainly contact the council staff with a view to dealing with this now that it's in court. You can certainly liaise that through your planner and certainly through the lawyers you've engaged to deal with this appeal.
Yep.
I encourage you to do that. So thank you for that. So I think we'll now move on to the next item, which is 34 Frenchman's Road, Randwick, and Mr. Michael Wood. So if we could get Mr. Wood's face. Michael.
G'day, how are we going?
The floor is yours. You have 3 minutes.
Thanks very much. And it's interesting to hear the comments about negotiation. And I think in this particular application, it couldn't be more different, simply because the application is for the demolition of the dwelling. I should declare an interest of sorts, I suppose, and my property adjoins the property at 34 Frenchman's Road, and my property is currently listed for sale. The advice that we've been given is that, by the listing agent, is that the development would have no impact on the valuation of the property at sale, though it's turned out to be not the case with prospective purchasers. That's not really the reason for the objection. Our objection fell into 3 main categories. The first was as to form, and I won't pursue that any further, other than to say the form of the application was so poor that it became very difficult for us to assess the impact of the development on the property. But what we can say is that that we have a 14-metre boundary with the property. There will be not 1 but 2 swimming pools owned by separate proprietors. Those pools will be close to the boundary fence, which is actually incorrectly located because of the position of the footing for the garage that's currently on the property, which meant the fence had to be moved closer to our side of the boundary. But what we can also say is that the setbacks are such that there will be a solar impact on our property at a side where there is a living area and an outdoor entertainment area, so there'll be an impact there. The other concern related to excavation, it's very difficult to tell how substantial that excavation will be, but by the looks of it, it's more than 100 cubic meters. And it is strange that that excavation will take place when the developer is concerned about a subterranean watercourse, which is the reason why he can't fix the property. But the reality of that situation is that will cause significant amount of material. My guess is somewhere between 100 and 200 tonnes. And that will need to cross the footpath on Frenchman's Road, which is a significant danger to kids walking to school. The school's 400 metres away. So that was some of the concerns we had about the impact of the development on our property. The next was the heritage implications, and really the only thing that was provided was a heritage impact assessment report. I contacted the author of the report. I asked to speak with him, and I asked him to provide one single example in his 20 years of experience as a heritage architect of a project that he had been engaged in where he restored a dwelling to its original condition, and he refused to do so. I find that amusing because it seems that the report pays scant regard to any of the heritage value of the property, notwithstanding identifying the original owner of the property and his importance in the community at that time. I've lived in our property for more than 30 years and am very much aware of the people that were living in the dwelling. It's a classic example of someone who stayed in the property for longer than they were capable of looking after it. The dwelling's 100 years old. They take a lot of work. And in fact, that's the reason we're selling our current property, because I'm old despite my youthful looks. And my wife is old, and we just cannot keep the property up to the standard that it requires. The dwellings are more than 100 years old.
So, Michael, do you support the recommendation for refusal?
100%. And I was going to come to another point, which, so in other words, the developer has no interest in renovating the property. What I can tell you is that every single complaint that was made about that building and the inability to restore that building, I have dealt with personally. And I am aware that other people in the Crescent have done exactly the same thing. And in my objection, I gave a list of some, but not all of the works that we've done, including but not limited to underpinning the foundations. It is not a significant issue, and it's not a significant issue because the subsoil is not reactive clay. It drains very, very quickly. In fact, I have 2 absorption trenches in the backyard of my property because of the slope doesn't permit drainage into the street. That was approved by council in the last DA for our compliant development. The reality of the situation is that we would not object to an extension of the existing dwelling. And in fact, our neighbours in number 5 Kelly and Crescent have done that. And we were looking forward to that dwelling being given new life. The application for inclusion as a heritage zone acknowledges that some of the dwellings have received unsympathetic renovations, I think it says, over the years. So in our view, that's not a reason, that the fact that that's occurred is not a reason why the building needs to be demolished. The harsh reality is the guy runs a company called Future Flip. I'm sure you're aware of the term. He has no interest in restoring the building. He wants to make money. And whilst that's not an issue, I don't think, for the committee to consider, it means that you have to take some of the claims that are made about the state of the property more carefully. There's a photograph of rising damp on a metallic structure. You fix that by cleaning it. Rising damp on a metallic structure is not a problem.
Okay, you've had way more than your 3 minutes. Is there anything that's not in the report that we don't know already from the reading report that you want us to know?
No, other than the council has required others at great expense to comply with the conservation listing. The most recent case being number 6, where windows were required to be of a particular type. So we also think that there needs to be consistency in the council's approach to development applications, and demolition would not be consistent with its approach to other applications.
Okay, thank you. Thank you for that. Thank you. Thank you very much indeed. We'll now move on to item 3, which is 35 Douglas Street, Clement. And I assume the architect on behalf of the applicant, Mr. Jeffrey Bakey. Is that right? How do I say your name? Sorry, please get it right.
Jeffrey Bakey.
Bakey, there you go. The floor is yours.
Thank you very much. Yeah, so I'm Jeffrey from Bakey Core Architecture. We've been working with the applicants Lara and Greg to develop a design for their new family home at 35 Douglas Street. The property, as I believe you visited this morning, it's at a beautiful location with northeastern aspect, with ocean views towards Waverley Cemetery and a green outlook towards Varna Park. We're very happy to see the council's recommendation for approval in the report. I just wanted to highlight that a key driver for the project was to implement sustainable design strategies while enjoying this beautiful setting. We wanted to capture the low angle sunlight from the north, locate window openings to capture that cooling summer afternoon nor'easter breeze, and develop enough adequate overhangs to shield the intense summer sunlight. Essentially develop a floor plan where the occupants can feel thermally comfortable throughout the house, throughout the whole year. So that was a big driver behind Lara and Greg when they first contacted us to develop their house. As you're aware, the project is on quite a complex site, a unique L shape with a moderate level change on the site and then further on the adjoining properties, and shares boundaries with many neighbours. We believe the proposal is appropriate response to the site and in keeping with the surrounding natural and built context. Following the initial DA submission, we received the request for additional information request. We've taken on the feedback from council and neighbours, and we developed the amended proposal. We had many conversations with the assessing officer, Elizabeth from Randwick Council, to address the items raised. And yes, these items range from deep soil planting calculations, landscaping items, view sharing diagrams, some complex engineering with the driveway and front stairs. And ultimately, we've taken a lot of the feedback on board and we amended the design, and the recommendation from Elizabeth was for approval, which is we're very glad about. Just one of the key item I'd like to speak to were privacy concerns from the neighbours. We've tried to implement measures to minimise overlooking, and we prepared towards the end of our drawing package privacy diagram sections, and in all the sections we submitted, you can see we have largely eliminated direct sight lines to windows, doors and private open spaces of many of the adjoining properties on the low side. But in this amended proposal that we put forth, we looked at strategies of reducing the balcony footprint increasing roof gardens, increasing the setback of two of the bedrooms upstairs, and we also put these low-level privacy screens to minimise direct sight lines, while also not conflicting with increasing building envelopes and building bulk and scale.
Okay with condition?
Sorry?
You okay with condition 2?
I don't have that condition right in front of me. Would you be able to read that condition? Sorry.
But it relates to amendments, and it relates specifically to privacy screens, sill heights.
Yes, that was in relation to the bathroom upstairs facing west. Yes, we're okay with that condition.
To the ground floor living room balcony and first floor balcony to bedroom 2 and 3. And talks about translucent obscured glazing, fixed lattice slats, fixed vertical and horizontal louvers. Then it talks about sill height. In the first floor bathroom window to the southwest, they want a sill height of 1.6 metres. Pool per coping is to be reduced by 500 mil. Landscaping screen along the northeast boundary, adjacent to the pool to reach minimum of 1.8 high. Boundary fence 1.8 from existing ground. So there's a range of conditions there that go to the issue of privacy. I'm just wondering whether they are acceptable to me.
Yes, I believe so. The addition of privacy screening to the upstairs bathroom and the reduction in the pool coping to increase the setback from the side boundary. We were, yes, the applicants were happy to take that feedback on board, those conditions.
Bedrooms 2 and 3. Bedrooms 2 and 3 must be constructed with either translucent or obscure glazing, a film such as a film applied, fixed lattice slats with individual openings not more than 300 mil, or fixed and vertical or horizontal louvers with individual blades angled and spaced appropriately to prevent overlooking. That's quite, I don't know whether that is something.
Yes, sorry, I'm not aware of that exact condition. Were these
I'm just asking.
were these these conditions, were they based on the original DA application?
They're on the assessment report. Attachment 1.
Sorry, yeah, I'm just a bit unsure that I reviewed the report. I didn't see any further conditions on bedrooms 2 and 3.
So they're saying either translucent or obscure glazing, lattice screen, or fixed lattice slats or fixed louvers. I'm wondering if you have any views with those.
Well, yeah, we're happy to implement those measures, but on those 2 particular rooms, I was not aware that further measures were going to be implemented. So we wouldn't want additional screening to those 2 particular bedrooms. As part of our amended proposal, we suggested low-level privacy screens at the edge of the balcony. They're not full height privacy screens. So yes, would you be able to please reference the page number that
it's in attachment 1.
Yep.
That particular item on the agenda, which is D3.
Page 167.
This page, 116. The actual conditions are 165 of the There's a reason I asked the question. It's up on this screen, if you can read it on the screen.
Yes, thank you. Thank you very much.
The reason I asked the question is because that's requiring quite a lot of screening on those doors, which are opening doors. So I was just asking a question.
So I think the confusion is, yes, sorry, I'm just getting a bit confused in that, yes, we've noted new privacy screens there. And yes, we're happy for the detailing that's been suggested in terms of the spacing. So I wasn't sure if we nominated a height for those screens on our drawings. I wasn't sure if council was putting forth further heights. But yes, we're happy with those requirements in terms of the spacing of the screening elements at the heights that we've indicated on our architectural drawings.
So you're happy with the wording of condition 2? There's nothing in there you want us to consider?
No, well, we're happy with that. Yes,
Okay, all right, thank you.
Sorry for the confusion there.
Any other questions from the panel?
No, thank you.
Great, thank you very much.
Thank you.
Thank you. And I'll now close the meeting at 1:31.